Hi dear students, hope you're all doing good. In this sixth video, we are going to deal with the ingredients of crime. This is a genesis of how crime as we see today got its shape theoretically. So this lecture is more on criminology than of a crime. Let me explain what is criminology. It is a scientific study of the non-legal aspects of crime and delinquency, including its causes, correction and prevention from the viewpoints of such diverse disciplines. Of this, as far as this lecture is concerned, the jurist Jerome Hall's General Principles of Criminal Law book is mostly consulted, and his theories and classification of legal principles are referred to. Meaning thereby, this video is more on philosophical aspects. This would enable you to understand the genesis of a crime. So when I said the topic is on ingredients of crime, it also means that when an act is considered to be a crime, there are 7 interrelated criteria to call an act a crime. Any behavior would not be a crime unless all these 7 conditions are present. They are as follows. Firstly, it is harm. The effect of a behavior has to result negatively to call it harmful. The English philosopher John Stuart Mill proposed this harm principle. The doctrine conveys that people should be free to act as they wish unless their actions cause harm to somebody else. The principle is a central view of a political philosophy known as liberalism. A crime has a harmful impact on social interest. You know, there is the saying, your right to swing your fist ends where my nose begins. It means every society is composed of multiple individuals, therefore, any person's actions affect others. Hence, be vigilant in anything you do it might cause harm to others. Secondly, it is illegal. The harm must be legally forbidden and must have been prescribed in penal law. Antisocial behavior is not a crime unless it is prohibited by law. For this, read about the maxim nulla poena sine lege, which means there is no crime without law. That means if to book a person under any crime, it needs to be a crime under the law prevailing in the country. For instance, adultery used to be a crime under IPC until judicial precedent of Joseph Shine versus Union of India 2019 3 SEC 39 decriminalized the same. Or same-sex relationship under section 377 was a crime until Navtej Singh Johar and others versus Union of India AIR 2018 SC 4321 read it down. So understand the interpretation under section 43 of IPC, which says the word illegal is applicable to everything which is an offence or which is prohibited by law or which furnishes ground for a civil action, and a person is said to be legally bound to do whatever it is illegal in him to omit. Then comes the next element of malified conduct. There must be the criminal conduct, that is, there must be an intentional or reckless action or inaction which brings about the harmful consequences. For example, a doctor's commission or omission can result in negligence. In legal language, it is actus reus, which we already discussed. For criminal intention, it is a legal term we call as mens rea. Criminal intent must be present in act committed or omitted. Here, you need to know that motive is different from criminal intention. The motive for a crime may be good, but the intention is always criminal in nature. Thus, if a man kills his starving children, his motive is good, but killing is legally forbidden, and so his intention is criminal. Fifth, concurrence of intention and conduct. This we discussed as the legal maxim, actus non facit reum nicis mens rea. There needs to be an act and mens rea to constitute the crime. That means there must be a concurrence of criminal intention and conduct. Example, if a policeman who goes into a house in order to make an arrest is not a trespasser from the beginning, since there exists no malified intention. There is thus a need for the act and mens rea to come together in the harmful act as a single act or as a series of acts. In the classic case of Tabo-Mili decided by the Privy Council, the appellants took their victim to a hut, got him drunk and then attacked him by hitting him around the head. Thinking that he was dead, the appellants put the victim's body at the bottom of a cliff to make it look like an accident. But in fact, the victim was still alive and died of exposure being at the bottom of the cliff. So when the appellants were booked for the crime murder, you know what they stated? They divided the act into two ways, before pushing to the cliff and after that stated that there was no coincidence of actus reus and mens rea. They stated that at the time of hitting, there was mens rea, but there was no act of killing. And at the time of pushing to the cliff, there was no mens rea, but there was an act. However, the judgment stated the killing could not be divided into separate transactions in the way the appellant suggested. The attack at the hut and the abandonment of the victim at the cliff were part of one ongoing actus reus. It was enough that the appellants had the requisite mens rea at some point during this ongoing actus reus. Sixth, casual relationship. There must be a casual relationship between the legally forbidden harm and the voluntary misconduct. Example, if Mr. Y, who got hospitalized due to a blow from Mr. A, suppose eventually died due to jaundice which has no proximity with the blow, Mr. A cannot be made liable. Or if a man dies of suffocation and then being shot at, the death of the person has nothing to do with the shot. There is a famous case R versus White, 1910 to King's Bench 124, where Mr. White gave poison to his mother and eventually she died. However, medical evidence proved that the mother had died from a heart attack and that the poison was in no way connected to the death. Therefore, it was established that the defendant's behavior did not contribute in any way to the resulting death. So, the link between the act done and the resultant offence is important to establish before accusing any person. 7. Prescription of punishment. There must be legally prescribed punishment. The misconduct must be punishable by law. So, dear learners, for understanding more on these 7 ingredients, read Jerome Hall's General Principles of Criminal Law book. Thank you.